Chapter 15. Understanding Judiciary. Reading Objectives. Judiciary. The Supreme Court. High Courts. Subordinate Courts. Munsif and Magistrate Courts. Lok Adalats. Role of Courts. The Council of Ministers, Cabinet, is the supreme directive authority which controls the whole of the executive government of the Union. There is another supreme body, judiciary, which is independent and separate from the executive and legislative bodies. The Indian judiciary is partly a continuation of the British legal system established by the English in the mid-19th century based on the typical hybrid legal system in which customs, precedents and legislative laws have validity of law. The Constitution of India is the supreme legal document of the country. There are various levels of judiciary in India. Different types of courts, each with varying powers depending on the tier and jurisdiction bestowed upon them. They form a strict hierarchy of importance, in line with the order of the courts in which they sit, with the Supreme Court of India at the top, followed by high courts of respective states with the district judges sitting in district courts and magistrates of second class and civil judge, junior division, at the bottom. Courts hear criminal and civil cases, including disputes between individuals and the government. Enrich yourself. Police. The police is a state subject and its organization and working are governed by the rules and regulations framed by the state governments. These rules and regulations are outlined in the police manuals of the state police forces. Each state, union territory has its separate police force. To enable the police to have greater and speedier reach and the public to gain easier access to police help, police posts have been set up under police stations, particularly where the jurisdiction of the police station, in terms of area and population, is large. In order to maintain law and order of a locality and protect the life and property of the people, police chowkis and police stations are established. Each police station is headed by Station House Officer, SHO, not below the rank of an Inspector of Police. There are clear guidelines and directions of the Supreme Court that it is an obligatory duty to the police to receive and record the First Information Report, FIR. The refusal of the officer may make him liable to punishment under law and he can even be terminated from the services. Police have no power to punish the criminal, and have no direct role in civil matters. Judiciary. The judiciary of India is an independent body and is separate from the executive and legislative bodies of the Indian government. The judicial system of India is stratified in various levels. At the apex is the Supreme Court, which is followed by high courts at the state level, district courts at the district level and Lok Adalats at the village and panchayat level. The judiciary of India takes care of maintenance of law and order in the country along with solving problems related to civil and criminal offences. The Supreme Court is the highest judicial body in India. The Supreme Court came into power on the 28th of January 1950, just 2 days after the Constitution of India came into effect. In the initial stages, it had its office in the part of Parliament House. The Supreme Court is endowed with many duties and responsibilities. The biggest responsibility is that it is the highest court of appeal and is also the protector of the Constitution in the country. Composition. The Chief Justice of India and 25 other judges make up the Supreme Court of India. The appointments are done directly by the President of India. There are certain criteria that have to be fulfilled by the advocates to become a judge of the Supreme Court. Being a citizen of India is one of the most important criteria. Apart from this, the person has to have an experience of minimum 5 years as a judge in the High Court or any other two courts one after another. He should also be a prominent jurist as per the President of the country, so that he can take up responsibilities well. The Chief Justice is also consulted at the time of appointment of the judges in the Supreme Court. Qualification of judges. A person is not qualified for appointment as a Supreme Court judge unless he is a citizen of India, either a distinguished jurist, or has been a High Court judge for at least 5 years, or has been an advocate of a High Court, or 2 or more such courts in succession, for at least 10 years under Article 124, 3. Tenure of judges. No minimum age or period of office has been fixed for the Supreme Court judges. However, a judge may remain in the office till his death or on attainment of age of 65 years, whichever comes first. On resigning from the office under a written resignation to the President. On being removed by the President by passing a majority resolution in the Parliament for proved misbehavior and incapacity. Removal of judges. A motion seeking the removal of the judge can be referred before either House of Parliament. If it is to be introduced in the Lok Sabha, it should be signed on by not less than 100 members of the Lok Sabha. If it is to be introduced in the Rajya Sabha, the motion should be signed in by not less than 50 members. The resolution should be supported by a majority of total membership of both the houses and 2/3 majority of the members present and voting. Other points. The Chief Justice can appoint ad hoc judges in the Supreme Court after the consent of the President. Important aspect is they should be qualified to do so. The Chief Justice, with the previous consent of the President, may request a retired judge of the Supreme Court and retired judge of a High Court who is duly qualified to be appointed as a judge of the Supreme Court, to sit and act as a judge of the Supreme Court. Supreme Court normally sits in New Delhi. Its meetings can be held outside if the decision is taken by Chief Justice on consultation with the President. Jurisdiction or powers of Supreme Court. The Constitution provides that the jurisdiction of the Supreme Court is of 3 kinds. 1. Original, 2. Appellate, and 3. Advisory. In addition, it has jurisdiction to issue writs to enforce the fundamental rights. Original jurisdiction. Article 131 deals with the original jurisdiction of the Supreme Court. By original, we mean the authority to hear and decide a case in the first instance. It has the exclusive authority to hear and decide a case which no other court in the country can hear or decide. For this purpose, both the parties to a case must be units of the Indian Federation. Thus, a case between an individual and a state cannot be heard by the Supreme Court. International treaties also cannot be heard by the Supreme Court under this jurisdiction. The cases which come under this jurisdiction of the Supreme Court are those between the Union Government and one or more states of India, between the Union Government and one or more states on one side and one or more states on the other side, between 2 or more states. Appellate jurisdiction. As a court of appeal, the Supreme Court is the final appellate court in the country. Appellate jurisdiction means where the Supreme Court is empowered to review the decision of a High Court. The Supreme Court in this case may uphold or reject the lower court's decision, or can direct the lower court to reopen the case for fresh hearing. The Supreme Court as an appellate court hears both types of cases: first, criminal cases where criminal activities are involved, and second, civil cases where the disputes regarding property and personal matters, like marriage, inheritance, wills etc., are involved. Article 132, 133 and 134 govern the appellate jurisdiction of the Supreme Court. Advisory jurisdiction: the President may, under Article 143, 1, make a reference to the Supreme Court for its consideration and opinion on any question of law or fact. Such references are heard by a bench of not less than 5 judges. Technically, the lower courts are not bound to accept the Supreme Court decision as advisory court, but such decisions have always been respected by the courts. Independent judiciary: the judiciary in India is not influenced by the legislature or the executive. In fact, it is the third wing of Indian polity. The judges are not appointed by the politicians and bureaucrats but by the President, and that too after consulting the Chief Justice of India, and in case of the High Court judges, the Governor of the state. The judges are not removed by the President. It needs a two-thirds majority of Parliament members to back a resolution for removing a judge for his misbehavior, misuse of power or incapacity. High courts: there are high courts in almost all the states of India and the Union territories. The high courts work under the Supreme Court in the country. These courts are vested with a lot of power. They decide on both civil as well as criminal cases. Most of the cases that are handled by the high courts of the country are passed on from the district or lower courts. The Parliament can put a union territory under the jurisdiction of a state high court for a union territory, such as Delhi High Court for Delhi, but Madras High Court looks after Pondicherry. Maharashtra High Court has jurisdiction over Dadra and Nagar Haveli, and Kolkata High Court has jurisdiction over Andaman and Nicobar Islands. Composition: the judges of the high courts are appointed by the President of India, in consultation with Chief Justice of India and the Governor of the states. The Chief Justice heads each of the high courts in India. The numbers of judges vary from one court to other depending upon the area that the High Court covers and the number of cases it handles. There are also high courts that serve more than one Indian state or union territory. Each of these courts have original and appellate jurisdiction under them. Summons can also be issued by the High Court. Revenue matters are dealt by original jurisdiction, while an eminent jury handles original criminal cases. Qualifications: almost the same qualifications are required for a High Court judge that are required for a Supreme Court judge, which are: 1. He must be a citizen of India. 2. He must have served as a judge of a civil or sessions court in India for at least 10 years. 3. He should have been an advocate with experience of a 10 years practice. Jurisdiction or power of High Court: besides the original and appellate jurisdiction of the High Courts, the Constitution vested in the High Courts for additional powers. 1. Power to issue writs or orders for the enforcement of fundamental rights or for any other purpose. 2. Power of superintendence over subordinate courts. 3. Power to transfer cases to themselves pending in the subordinate court involving interpretation of Constitution. 4. Power to appoint officers. The High Courts are primarily courts of appeal. In the matters of admiralty, probate, marriages, contempt of court, enforcement of fundamental rights and cases ordered to be transferred from lower courts, the High Court has original jurisdiction. On the appeal side, they may entertain appeals in civil and criminal matters from their subordinate courts as well as from their original side. Subordinate courts. The Constitution provides for the appointment of district and subordinates courts. These courts function in the districts and are under the administrative control of the high courts. Qualification of district judges. He should be either an advocate or pleader or an advocate with 7 years standing. He can be an officer in the service of the state or union. Appointment. The district judges are appointed by the government in consultation with the Chief Justice of High Court. The subordinate court judges like the magistrate and munsifs of lower courts are appointed by the State Public Service Commission by a special examination. The candidate must have the experience of 3 years as lawyer. The civil cases are heard and decided by the district court and the presiding officer is designated as the district judge. The same officer is designated as the sessions judge for hearing and deciding the criminal cases. Munsif and magistrate courts. These are the lower courts which work under the supervision of the district courts. These are the courts designated as the Munsif's court, the court of magistrate of first class and the court of magistrate of second class. Searching dictionary. Inheritance. The money, property, etc. that you receive from the previous owner when he dies. Infringement. To break a law or rule. Assault. The crime of attacking. Illegal. Now allowed by the law. Lok adalats. A Lok Adalat has the jurisdiction to settle, by way of effecting compromise between the parties, any matter which may be pending before any court, as well as matters at pre-litigative stage, i.e., disputes which have not been formally instituted in any court of law. Such matters may be civil or criminal in nature, but any matter relating to an offence not compoundable under any law cannot be decided by the Lok Adalat even if the parties involved therein agree to settle same. The Legal Services Authorities Act, 1987, as amended Viday Act No. 37 of 2002, provides for setting up a permanent Lok Adalat, which can be approached by any party to a dispute involving public utility services, which have been defined in the Act, as amended, to include transport services for the carriage of passengers or goods by air, road or water, telegraph or telephone services, insurance service, as also services in hospital or dispensary, supply of power, light or water to the public, besides systems of public conservancy or sanitation. Role of courts. The courts have to hear both civil and criminal cases. The district courts and the subordinate courts have their own jurisdiction of hearing the cases. The jurisdiction of courts is determined by the valuation of the properties involved in civil case and the nature of the criminal case. Police. The police is a state subject and its organization and working are governed by rules and regulations framed by the state governments. Each state, union territory has its separate police force. The gazetted police officers at the state level are appointed by the state public service commissions. To enable the police to have greater and speedier reach and the public to gain easier access to police help, police posts have been set up under police stations, particularly where the jurisdiction of the police station, in terms of areas and population, is large. Districts are sometimes divided into about 6 subdivisions and each subdivision is headed by a Deputy Superintendent of Police, FIR. The First Information Report, FIR, is the information given to the police when a crime happens. Anyone who knows about the committing of a cognizable offense can file an FIR. A police officer who comes to know about a cognizable offense can file on FIR himself, herself. The police have no power to punish a criminal. They only arrest the criminals and investigate the case. Word to know: India has a single judicial system. The Supreme Court is at the head of the judicial system in India. Supreme Court is the highest court of law in the country. Parliament organizes the jurisdiction of the Supreme Court. High Court is the highest court of a state. Besides original and appellate jurisdiction, the Constitution has vested 4 more jurisdictions of high courts. Lok Adalats are voluntary agencies and settle the dispute outside the courts. Police stations are headed by SHOs not below the rank of an inspector.